In Malaysia, Chinese customary marriage were used to be recognized as polygamous. We have a number of cases to illustrate this. The first case is Dorothy Yang Nam and Li Fah Kui case. Here, a Chinese would contract a marriage either monogamous or polygamous where it must be proved to the court's satisfaction. The courts have given judicial recognition to certain customs prevailing among Chinese race irrespective of their domicile or religion. And the next case, Chu Angchi and Yeo Chan Nyo, or is famously known as the Six Widows case. In this case, the Chinese marriage under customary law were held as polygamous. It was recognized in the Strait Settlements based on two reasons. The first one is by recognition by the Charter of Justice, and the second reason is due to public policy, where hardship would be caused if Chinese polygamous marriage were not recognized, especially on the welfare of the women who become concubines. Thus, legal recognition of polygamous marriage implies that all wives of the marriage would acquire equal legal status, thus enable them to get equal share in inheritance of the property of the husband upon his death. For example, in the Six Widows case, the court held that the widows, either they are principal or inferior wife, were all entitled to divide equally amongst them the 1/3 share which the statute of distribution gave to a widow. Recognition of the validity of polygamous marriage also implies that all offsprings or children of the marriage were legitimate. In the case of Hu Hui Leong, the court held that the courts in Strait Settlements had recognized the polygamous marriage among the Chinese, and as a consequence, recognized also the legitimacy of their offsprings. However, by virtue of the Law Reform Marriage and Divorce Act 1976, a Chinese could no longer enter into polygamous marriage. According to Section 5, Subsection 3 of the Act, after the coming into force of the Act, every person who marries under any law, religion, custom or usage shall be incapable, during the continuance of such marriage, of contracting a valid marriage with any other person under any law, religion, custom or usage. Under Section 6, marriage contracted in contravention of the provision shall be void, and the women will have no right of succession or inheritance on the death intestate of the male person. And under Section 7, Subsection 1 of the Act, a contravention of Section 5 will lead to a criminal offence of bigamy. Despite the enforcement of Law Reform Act on Chinese, customary marriages which were entered before the date of 1st March 1982 is still enforceable or valid. This can be proven in these few cases. For example, in Sabrina and Hu Unjin, a Chinese customary marriage contracted in 1982 was accepted by the court based on the intention, cohabitation and repute of marriage of both parties. In another case, Leong Wishing's case, the performance of tea ceremony was an integral part and proof of a Chinese customary marriage. Whereas in the case of Ri Li Chun Guan disease, the court held that although no ceremony was made, it does not need to be proved. It was only necessary to prove that there is an intention to form permanent union, there was a long continued cohabitation between the parties, and there was repute of marriage, which is recognition by the husband's family as the strongest form of reputation of marriage. In another case, Chia Tai Pin, the court also held that proof of performance of a ceremony was not essential to establish the relationship. And in the case of Chu Giok Kiao, the court held that the law merely required a consensual marriage of mutual consent to marry. Requirements of a ceremony, formal contract or repute of marriage were evidentiary only, and it is not essential to the acquisition of status of a second wife. A photograph was also not conclusive evidence of proof of marriage, and neither was the adoption of children by the parties. Thus, the issue here is whether the parties of unsolemnized and unregistered Chinese customary marriage entered into after the LRA comes into force could seek divorce. In the case of Yeo and Chu, the facts of this case was that the parties had a dinner function at a temple on 1998 to commemorate their marriage, and since then they had cohabited as husband and wife and had a child. However, the marriage was not solemnized according to the Law Reform Act. The petitioner then claimed for divorce, and the court held that the court could not grant divorce because the marriage was void ab initio from the beginning. Moving on to customary laws in East Malaysia. Customary law in East Malaysia primarily consists of Malay customary law. It exists in three forms, such as codes, judicial decisions, and statutes, where it is provided as a mixture of Islamic law and adat. Relating to Malay custom in Sabah, it is a mixture of Islamic law and Malay adat, and Islamic law was applied as part of native customary law, for example, in matters of marriage, inheritance, property, and betrothal. And there was also no uniform application of Malay adat. This can be illustrated in a few cases, but let's look at the example in the case of Matusin and Kawang, where this is a matter of marriage between a Muslim Bugis woman and a Muslim Brunei Malay man, which was made according to Islamic law. They lived for 40 years within the Bajau society, and they also adopted 2 boys and 1 girl. On the death of the man, dispute arose on the distribution of his estate, and the court held that the adopted children were entitled to be treated as their own children, and the deceased sister was excluded from inheritance. Thus, Malay adat was applied as racial law of the Brunei Malay. Looking at the Malay custom in Sarawak, it is also the same as in Sabah, where it is a mixture of Islamic law and Malay adat, and it is embodied in Undang-Undang Mahkamah Melayu Sarawak 1915. In the case of Mahada and Chi, the court recognized Malay adat, although it was contrary to English law. Thus, a pregnant woman's oath that a particular man was the father of a child was admissible, as the case falls under Malay adat. Malay custom in Sarawak can also be seen in the other 2 cases as stated here. Moving on to native customary law as another group of customary law existing in Malaysia. Native is generally identified by descent and their way of life. Their definition is found in legislation and also judicial interpretation by courts. Looking at the definition by legislation, we can refer to Article 161A, Clause 6 and 7 of the Federal Constitution, where native of Sarawak must be a citizen and either belong to one of the races in Clause 7 as indigenous or is mixed blood exclusively from those races. And native of Sabah must be a citizen, the child or grandchild of person from race indigenous, and must be born either in Sabah or has father domicile in Sabah at the time of the birth. Whereas in the Schedule to Sarawak Interpretation Ordinance, it lists out the races regarded as indigenous to Sarawak, similar to Clause 7 of Article 161A above. Section 3 of the Interpretation Ordinance 1952 also provides that native of Sabah is a person whose parents are or were members of people indigenous to Sabah, or person resident in Sabah and living as member of native community, and at least one of the parents or ancestors is or was a native, or a person resident in Sabah and a member of either Suluk, Cagayan, Simonol, Sibutu or Ubian, or member of people indigenous to Sarawak or Brunei, and has lived as member of native community for 3 years continuous period and had good character during the period, and the staying in Sabah is not limited under Immigration Ordinance. Native is also defined under Section 20, Subsection 1 of the Native Courts Ordinance 1992, where it gives power to the Native Court to determine status of native of a person. Determining factors include the conduct, mode of life, testimony of members of community, and also opinion of assessors. The Native Court may issue certificate to declare that the person is a native. With regard to definition by court's decision, we have a few cases that talks about native status. In the case of Liu Siu Yin, the Native Court of Appeal held that to obtain certificate as a native, the requirements in Section 3 of Interpretation Ordinance 1952 had to be fulfilled. Here, the appellant has to prove to the court that he was ordinarily resident in Sabah, living as member of native community, and one of his parents is a native. In this case, appellant failed because he was married according to Chinese customs, gave children Chinese names, he never paid poll tax, and he lived in a heterogeneous society. However, in the case of Ong Seng Kee, the applicant succeeded because he has managed to prove that he lived in a predominantly native area and he had assimilated into the native community by participating in native festivities and ceremonies. Similarly, in the case of Law Tangi, even though the applicant's father was a Chinese, but he had a native name, he was accepted as a member of Dayak community and he paid door tax to Dayak and he was buried in the Dayak cemetery. Thus, he was regarded as a native. Aside from that, a person from Peninsular Malaysia may also be certified as a native. This can be seen in the case of Datuk Secretary and Government of Malaysia, where decision of the Native Court declaring the applicant as a native of Sabah was final decision and a conclusive evidence. He was declared as anak negeri under the Interpretation Ordinance. A corporation is also not a native. This can be seen in the case of Manang Sdn Bhd and Manang Selaman, where the definition of native only covers natural persons for the purpose of holding property, such as native customary land. But a company may hold land as native if it is given mandate by the Yang di-Pertua Negeri under the Land Code. Aside from that, religion is not a criteria in determining native status. Conversion of a native to another religion does not affect his native status except for Muslim native. A Malay is a native, but since Malay is a Muslim, then his personal law in marriage, divorce and inheritance should be Islamic law and not native law.